We have breaking news tonight, right now, in the prosecution of Donald Trump in New York. We are tracking a brand new legal filing from the Manhattan DA, a name that many across America know since Donald Trump was arraigned, DA Alvin Bragg. And it's related to this new case, New York versus Donald Trump. It's out late today, and we have the filing. I'm going to get into these two pieces of it. This is what the filing looks like, and this is what it looks like when the former president threatens a DA, creating criminal evidence, which we're now seeing put in more than one case. This is brand new. We didn't know it was coming. I'm going to get into all of it right now. It's our top story. What we have is an aggressive move here by this DA to protect the legal jurisdiction, to stay on offense in New York on the prosecution of Donald Trump for those stated alleged felonies, what he was indicted for. Now, this new filing, which I said, brand new, we got it late today. If you haven't heard, you're hearing now, is suing specifically top Republicans in Congress for interfering in the prosecution. Now, if you're thinking that's unusual, it is. Indeed, the New York Times today calls this case and this filing a, quote, extraordinary step to counter what the Republicans in Congress are trying to do. The Judiciary Chairman you may have heard of, Jim Jordan, was trying to subpoena veterans of this same New York DA's office. Now, there's no big amount of funding to link them. This DA is local. Local prosecutors in New York and around the nation operate completely separate with no oversight from the federal Congress. That's the context legally for what I'm about to report for you. Bragg's suit accusing House Republicans for what he calls an unprecedentedly brazen and unconstitutional attack designed to threaten, chill, or retaliate. The DA's office telling the court that these House Republicans are trying to transparently intimidate and attack the district attorney. Now, no one knew this was coming today. The suit shows that Bragg is not going to just wait around in these skirmishes. He's not going to have, again, I'm holding up a piece of the filing, he's not going to have a criminal defendant, no matter who he is, swing a bat and threaten him and his office and the safety of the courts while allies in Congress try to subpoena or abuse the subpoena power. He's not just going to wait around. Mr. Bragg, DA Bragg, I can tell you from what we're seeing, recognizes that some of these Republicans are pushing a different kind of confrontation. This also shows that while Trump and his allies have a playbook, they used it against James Comey and Bob Mueller and other probes. It's well known by this point. Bragg has read it. And he's not only trying to act first, he's trying to outmaneuver them. Jim Jordan did, in a way, start this part of this fight, but it may backfire. And while Jordan has been so quick to threaten so many court fights, notice that tonight he is the defendant. He is on the other side of this one. He may lose this one. The DA arguing that what the Republicans are trying to do, subpoena a former line prosecutor to talk about an ongoing criminal prosecution, is no less of an affront to sovereignty than subpoenaing the DA himself. Well, that's not just rhetoric. Let me tell you exactly why that matters. The DA, Bragg, is deploying the power and the current legal authority of his office to protect a former employee, a veteran of the office. And it's a person he had disagreements with. We can get to that. But regardless of their disagreements about law or approaching cases, he is now using his legal powers to protect that individual and any other employees, saying, hey, going after them is like going after me, and you can't do that under the law in the middle of an open criminal case, not for a circus atmosphere, as he calls it. Now, there's been a lot of talk about treating a former president fairly in the courts, treating him like anyone else. And Trump has at times benefited from that, and he is afforded all the rights, including the presumption of innocence. But what we're seeing tonight with this new filing and other steps that I'm telling you about is that now that Mr. Trump is defendant Trump, now that he's been charged, the DA has to try the man at that table, defendant Donald Trump, as the actual defendant that he is. In real talk, this is not a typical defendant. Donald Trump, faced with indictments about cheating and lying, is already doing more of both. This came up inside his arraignment with the court artist drawing along. He was pressed on attacking the DA, on threatening violence, on lying about those very recent threats, on tapping this playbook I'm mentioning to try to get his government allies in Congress to basically interfere, to abuse power. Faced with an indictment about cheating, he is very publicly trying to work with other people to cheat to avoid a trial. But he, if he is properly indicted, should face a fair trial. And if he beats it at trial, so be it. Trying to get Congress to cheat him out of it is not fair. That's not what any other defendant is supposed to get. And that brings us to Jim Jordan here. So we know a lot more right now, tonight, than we did this morning, before this case was filed, or a week ago, about what Bragg is doing differently. We're starting to see a pattern of how DA Bragg has apparently learned from what other prosecutors face, some of whom have been outmaneuvered by Trump's games or his allies' bluster. Remember, leading into this arraignment just 1 week ago, legal experts were discussing how arraignments usually expected to take around 15 minutes. And that's true. But do you remember a week ago? Might seem like longer ago, the way we live these days, but the nation was standing by outside the courtroom, watching on televisions, listening on the internet and radio. People stood by for about an hour. That's how long that arraignment ran. It was actually one of the longest arraignments on record in New York this year. Why? Because the defendant is different, and he is finally being treated as he is. The DA moved differently that day with that aggressive step of making the arraignment so much longer because he came out swinging, his prosecutors hitting Trump first, putting him on defense over his recent attacks, going beyond, again, like I said, usual arraignments, introducing damning evidence, including something that now the DA has introduced in that day in court and in this new case, the evidence of Donald Trump swinging a bat, posting online, threatening. And that drew a rebuke a week ago from the judge who told Trump to refrain from any conduct that could incite violence or create unrest. He also said, do not engage in words or conduct that jeopardizes the rule of law. And that was the judge siding in a way with the DA's approach, saying, okay, this arraignment's going to be longer than usual. It's going to have bad evidence for the defendant. And we don't usually do that, but this defendant has created danger and bad evidence that must be addressed then, immediately. And that lays down a marker for more severe action. On Tuesday, they treated this defendant differently because he's not an ordinary criminal defendant. The DA acted. He punched first. And now a week later, when you look at this in context, that's why this civil case is such a striking filing. The DA is punching again. For all the memories of Bob Mueller and the January 6th committee and other probes who, by the way, were not independent like this. Both Mueller and the January 6th committee were part of the federal government. And much as Jim Jordan wishes otherwise, the local DA in New York is not part of the federal government. He has that autonomy, that authority. It's something that conservatives have long celebrated about American law. He has that independence under federalism. And he is moving different. There will be some, I expect, in the hours or days ahead who say, what's he doing suing Republicans? What did he do making that arraignment so long? Is any of this unfair to the bat-wielding defendant, Donald Trump? And those issues can be litigated in court. The defendant, even with his bat in hand and his allies trying to cheat him out of his day in court, the defendant has rights. The defendant is presumed innocent under our laws. But the Congress and the allies and anyone who would dare act on these threats of violence, well, they might find themselves joining this very famous defendant in the jurisdiction of New York.